Well, hello and welcome to the fourth in our series of COVID-19 WebEx seminars. Could I ask everyone just to place yourself on mute if you're not currently on mute to ensure that we limit any background noise? That would be really helpful. For those of you that don't know me, I'm Morag Hutchison. I'm a partner in the employment team here at Burness Paul, and I'm joined by my fellow partner Jen Skioch today for this session. We've also, I'm delighted to say, we've got a special guest today, Sarah Phillips, who is the head of our pensions team and is going to deal with some of the points that are coming up in relation to furlough and pensions. So we'll pick up with Sarah towards the end of the session. The structure today is, you'll all have seen, I'm sure, the new guidance that came out overnight, Friday night, Saturday morning, on furlough job retention schemes. So Jen is going to talk us through some of the issues that have come out from the new note. I'm then going to cover what Jen and I are currently referring to as the super questions, questions that we still don't have an answer to that are particularly important. I'm sure all of you will be aware of the issue around about holidays and furlough, so we'll cover that. We'll also look at sickness and furlough. There's still some questions over who can furlough, so we'll pick that up, and also the issue of TUPE and furlough. So we'll look at those questions. We'll then pick up between us, Jen and I, the questions that are being posted as far as we can. And then, as I say, I'm going to hand over to Sarah, who's going to cover off some of the pensions issues. As I've said, if you can ensure that you're on mute throughout the session, that would be ideal. The other point I have to make, of course, being a lawyer, is just to be clear that we can only give general advice on this session. We can't give individual advice. So if you do have kind of specific questions about your organisation, then obviously you can pick up with your normal Burness Paul contact. So without further delay, I'm going to hand over to Jen. Those of you that joined us a couple of weeks ago will recall that she had many bottles behind her when she was delivering the session. They may still look full. I'm, however, reliably told that that's just water, and the bottles that she's actually drinking from are under her desk. Jen has also told us that today she is in the line for a Hello Fresh delivery that may take place at some point through this session. So apparently she's number 10 of 33 currently. So if Jen has to disappear at any part during the session, you'll know why. So without further ado, Jen, if I can hand over to you to chat through the new guidance, that would be great.
Yeah, it's definitely my Hello Fresh delivery, not the fact that the questions are just too hard if I disappear. And also, I'm sure some of you are relieved to see me back and that I wasn't sacked for swearing on my last webinar. So very professional as usual. So yeah, I'm just going to run you through the updates that we've got from, I think, what is now the third iteration of the guidance from the government. On the scheme, I guess just an overarching comment, which I'm sure you'll all be feeling as we are, which is that it's not the same as getting a new piece of legislation out or something that's been crafted in precise language. I think we're all struggling with the fact that the guidance is in fairly loose language and is open to interpretation or different interpretations. So that's just a general observation that we have. So if you're feeling that, you're not alone. And it may be that you're just going to have to make judgment calls as best you can based on the guidance that we've been given. The other thing I just wanted to flag, and some of you may already be on top of this, is that at the same time as updating the employer guidance, the government have also updated the employee guidance. So you can flip between the two different web pages, and I think it's quite helpful to do that because your employees will be no doubt reading the employee guidance, and so if you're getting questions about what you're doing, then they will no doubt be based in the information that they're seeing in the employee guidance. So just make sure you're kind of taking a look at that as well. So just running through some of the updates. Which employers can claim. So it's those who have created and started their PAYE payroll system on or before the 28th of February. A new introduction of the guidance Saturday is that you were enrolled for PAYE online. So that's just something to note. They have stressed the point that it's all all employers in effect that operate this PAYE system, which includes the public sector, but they have emphasised the point that they don't expect that many public sector employers will use the scheme, because if they're receiving public funds already to make payments to their employees and they're still coming through, then there wouldn't be a need for the taxpayers to effectively fund that again. So if you fall into that category, just be extra careful when you're considering whether you make any claims. They've also included reference to individuals being able to furlough workers such as nannies or cleaners if they are paid through a PAYE system and were on payroll on or before the 28th of February. So that's some helpful clarification. Another kind of, I guess, macro question which you will all be thinking about when you're deciding whether to furlough is what's the trigger for furloughing employees? Do you have to be avoiding making those individuals redundant, or can it be a more broader kind of economic state of play that's affecting your business? So I think it's helpful to note that the employee guidance now says that you can be furloughed if your employer is keeping you on the payroll if they're unable to operate or have no work for you to do because of COVID-19. But then in the employer guidance, they talk about furloughing employees because you cannot maintain your current level of workforce, which would suggest to me a slightly narrower approach there of it being hinged upon the risk of redundancies. As I say, the wording on this is fairly ambiguous, but I guess our view is that the government's been clear that they want to provide as much protection to people as possible, and I think that the policy statement that they have made on this is the thing that you should be testing your rationale against. So they've said it's designed to help employers whose operations have been severely affected by COVID-19 to retain their employees and protect the UK economy. However, all employers are eligible to claim under the scheme, and the government recognises different businesses will face different impacts from coronavirus. So I think it's therefore quite a kind of specific decision for each of your organisations to make about whether you feel that the reason you're considering furloughing staff is a COVID-19 related reason, and if not, do you feel confident that the claims that you are making are in keeping with the spirit of the scheme? So that's just something to bear in mind. There had been, and I don't know whether it's just employment law nerds that were having this debate, but they had used the terminology of employees and then at different times workers, and we're all used to the different tests that apply from an employment law status point of view, but actually I think it's quite clear that they're adopting the kind of HMRC distinction of whether you're employed or self-employed, and the binary test that's being applied here is whether the individual was on your PAYE payroll at the 28th of February. So that will, of course, include traditional employees, but they've also said that it will now include, or clarified, it will include office holders, including company directors, salaried members of LLPs, agency workers, including those employed by an umbrella company, and Limb B workers, which are the kind of workers that we would more typically be referring to under general employment law principles. What I would say is that if your workforce is made up of any of those different types of workers, have a look at the updated guidance, because it actually has got separate sections for all of them with different considerations that would apply. I don't think it was in real doubt, but we've had express confirmation that apprentices are covered, and that if they do continue to do any training for you, then you'll need to make sure that you are paying them the relevant, either the apprenticeship minimum wage, the national minimum wage, or the national living wage as appropriate, and you'll need to make up the shortfall for that. So what we are calling new starts are people who were not on your payroll basically at the 28th of February, and so they started after that. There was heavy lobbying to the government about this group of individuals because it just feels as though they fall down a crack. They are, in a large number of cases, still employed by their new employer, but their new employer cannot secure funding for them under the scheme because they weren't on payroll on the 28th of February. So the Chancellor did a live Q&A on Twitter last Friday and confirmed that the position on new starts wouldn't be changing. The reason he gave for that was that they need, in his view, to have a cut-off. They need to have a cut-off so that the system isn't abused by people just saying, as soon as the scheme is announced, that they've got all these people employed for them that they're claiming for, when that may not have been a kind of good faith legitimate claim. And also he says so that they can go back and verify the claims against the payroll information at the 28th of February. So I can understand from a logical point of view those reasons do seem quite sound, but I think just on a human level, it feels inherently unfair that those individuals are employed and will no doubt be able to demonstrate that they they have legitimately been employed, but they aren't covered. So that will be a group of employees that employers will need to think carefully about what they're going to do on. And obviously, one option is for those employees to ask their previous employer to take them back under the rehiring provisions, which I'll come on to talk about. But that would only be if they had been on their payroll at the 28th. So it's quite a messy situation, I think, an unsatisfactory situation for those individuals. So employees who left after the 28th of February, you'll probably all have seen Martin Lewis was sort of promoting this as being his significant change that he managed to get through lobbying of the government. This is where people had left after the 28th and were effectively wanting to be rehired by their employer, but their employer was saying that the guidance was quite clear that you could only rehire if you'd made those people redundant. So, any other terminations wouldn't be caught under the old guidance. He, as he says, he believes he's managed to secure this change, which is that anyone who left after the 28th for any reason now can be rehired and furloughed by their employer. So I guess key points to note on that are that doesn't mean that it will automatically be a valid claim. If you do that, you'd still need to go through your kind of rationale testing to make sure that you believe it is a proper furlough situation for that individual. And just be awfully careful about, if you're the organisation that's deciding whether you do the rehiring, be careful about whether that is something that you want to do. It's not obligatory. You may feel from a moral perspective you want to do it, which is absolutely fine, but just think very, very carefully about the contractual mechanism that you use for doing that. Some outstanding questions are, what would happen to continuity of service? You'll all be familiar with the kind of preservation of continuity that happens when people are reinstated after a successful appeal, or if they get a job with their old employer within 4 weeks of being made redundant. There's a mechanism under the Employment Rights Act for preservation of continuity, so sort of magic wand is waved and it's as though the termination never happened. It doesn't, at this stage, that wouldn't apply here. So if you had a break in service, you would, I think, be arguing, if you were the employer, that it's a new start situation. But I do have a concern that we may see some retrospective changes there, or certainly employees may feel that they've got a claim for continuity if you are claiming for wages on a backdated basis. So I would say the rehiring issue is one that needs to be carefully considered and looked at if that's something that's relevant to your organisation. Clarification that anybody who's working reduced hours, you can't put a claim in for them. That, I think, my interpretation of that is it's a key principle of furlough that the person is not doing any work at all. So it kind of follows that you can't put a claim in for funding for people if they're still working. I think, though, that doesn't mean that anybody who is on reduced work and pay just now could never be furloughed. I think you could furlough them, which would involve them doing no work at all and then put a claim in for them. Employees who are receiving SSP, the position on that remains that if you're receiving SSP just in the ordinary like normal SSP world before COVID, or if you're receiving it because of the emergency legislation that has brought in additional coverage for people self-isolating due to COVID, then you can't be furloughed while you're receiving that. But once that absence or self-isolation period comes to an end and you're no longer receiving the SSP, then you could be furloughed by your employer if they decide that's the right thing to do. Morag's going to touch on the more tricky scenario of someone being on furlough and then what happens if they subsequently become sick after that. There were a couple of really significant changes and extension of the coverage under the updated guidance. So employees who are shielding in line with public health guidance and those who have to stay at home to be with those who are shielding, and an additional category of employees who are unable to come to work because they have caring responsibilities resulting from COVID. So all of these categories of individual would of course be eligible for what we're calling the kind of standard business furlough. So if you were furloughing all of your staff anyway, then of course these people could be furloughed as long as they weren't in receipt of SSP. But I think what the guidance does is that it attaches to them an additional furlough option that you could consider. So if they are unable to work from home and they are shielding or at home with someone shielding, have to be at home with them or caring, I think it opens up the possibility of furloughing them simply by virtue of that status. I think the rationale for that is that the government is imposing these restrictions on people, whether it's shielding or closing schools, which then means that people can't work because of their caring obligations. And so I think this is a bit of a safety net that they're putting in place for those individuals to avoid an employer saying, you can't come to work and do your job for us, so we may need to take action against you, up to and including dismissal. The only thing that concerns me with the guidance is that for the shielding employees, they refer to you can furlough them if you would otherwise have made them redundant. I think that's an incorrect use of the word redundant. I think what they're trying to get at there is if they can't work from home but they can't leave their home, you would be left in a situation where you would be looking at could you continue with their employment in those situations? But it would be really helpful to get some clarification on that. We've also had confirmation that you can take a second job while you're on furlough, and I think that for a lot of employers kind of goes against the grain a little bit, that they might be getting 80% of pay through the government scheme that you're facilitating and maybe even more perhaps if you're topping up, and then the government has said that it's possible for them to get another job, so they could end up in a more favourable financial position than had they been at work. That would always be subject to any contractual restrictions that you have in place that would prevent an employee from having another job, and so you may still take the view that you don't think it's appropriate for them to do that while they're furloughed. That would just be a decision for you to take.
Jen, Jen, sorry, Morag, I was just going to come in on that. I was on a webinar earlier this morning where it was a group of lawyers who were talking about exactly this point. And apparently one of the reasons why the government have changed their position on that is because they were under quite intense lobbying from the National Farmers Union, who were saying we really need people that are currently furloughed to come back into the workplace, or else we're not going to be able to harvest the crop, basically, and it's all going to go to waste. So I think that's why that's been changed. There was also the discussion about if you have a provision in your contract of employment that says that you can't take on another role, does that prevent an employee from doing that once they're placed on furlough if you don't change the contract? And I suppose the points that were made there were there's kind of two reasons why you would have that provision in your contract mainly. One is to ensure your staff aren't working over 48 hours a week. And the second is to ensure that your staff aren't working with competitors. And so the first one kind of falls away because your staff are on furlough. So you don't need to worry so much about the working time regulations there. The second one, absolutely, if you've furloughed someone and they go and work with a competitor, you could absolutely stop them from doing that. But there was a discussion about if you've furloughed someone and they want to go and help with, picking strawberries or helping a care home or whatever, if you prevent them from doing that and you don't have a reasonable reason for doing so, you could potentially end up with a constructive unfair dismissal claim. But I think it was one of those sort of academic discussions, because actually who's going to resign just now and claim constructive unfair dismissal? But thought it's just helpful to share that, because some of you will have provisions in your contract that say that employees can't go and work in a second job while they're employed by you. Just be careful if you're seeking to rely on that.
I think that's right, and I think also a consistent approach needs to be taken as well, because where you might find people saying that's a breach of trust and confidence is if some managers are taking a totally relaxed approach to it, and then others are sort of putting their foot down and saying, no, we don't give you your consent. In fact, you're not allowed to do that. So I think it's going to be interesting to see how many people do take up second jobs potentially through that. Helpfully, the employee guidance though makes it clear to employees that if they do that, they still need to prioritise their primary work, and if you tell them they need to come back to work and they're coming off furlough, then they have to do that, which I think is helpful, because otherwise it could have been a bit messy. Sorry, I'm taking up quite a bit of time here, Morag, so I'm going to run through my last few points so we can get on to questions.
Onto the important bit, Jen, is that what you mean?
Onto what you call the super questions, which I would say are maybe the nightmare questions, but okay, we're being positive today. When does furlough start? The guidance includes the following new wording. It says, claims should be started from the date that the employee finishes work and starts furlough, not when the decision is made or when they are written to confirming their furloughed status. So I guess that's just a practical point for you to think about in terms of when you're putting your claims in and the period that they're covering, and also maybe a bit of a relief for people who were struggling to get follow-up confirmation letters out if they'd already had conversations with people and had placed them on furlough, but they were wanting to get their confirmation letters out. It's from the day that they finish work and are on furlough. Just a signpost to say that the guidance contains further details on the calculation method for wages. They make it clear that you will have to calculate that yourself, so HMRC will not do that for you. So that's going to be quite a job, I think. But hopefully there's some smart payroll-y type software that will do that for you. I think, again, looking at it from the point of view of employees, what will they be expecting? Well, the employee guidance makes it clear, in fact, I think it says it 2 or 3 times, that their employer can claim for 80% of their regular monthly wages. So I think ultimately what you're looking at for most people will be a kind of what did they get over the last 12 months type approach to make sure that you're getting as much as is allowed under the scheme for them. There was a change to some of the things that had previously been excluded. They've now said that commission payments, which are compulsory, which our interpretation of that is that they are contractually due to the employee, can be included, and I think that's very helpful for workforces where there's a lot of employees who get a lot of their earnings through commission. So what is their normal monthly wages to them would certainly not feel as though that was basic pay. And then Sarah will come on to talk about salary sacrifice position and pensions as well. So I think that's it from me in terms of the what's been updated and what's been clarified. I'm going to hand over to Morag now just on the super questions. And I'm happy to chip in, Morag, as and when you need me on them.
Yeah, when I look like I'm not sure of the answer, Jen, is that what you're suggesting? Before we do that, do you want to just quickly pick up the question that's come in there? If employees were not furloughed until the 1st of April, does 3 months still apply in respect of claim from government, or would it only be for a 2-month period from start of furlough?
Yeah, I think the way we've got to interpret this is that the three-month period is the government saying we are operating the scheme for a 3-month period. So that is going to come to an end in principle at the end of May. They've said that they will extend that. So sorry, I'm terrified that there's a wasp in my flat as well. I'm causing a lot of problems today. If I looked horrified, it's because I thought there was a wasp flying towards me. So if you furlough people from the 1st of April, all you can confidently say is that the government scheme will allow for that to carry on until the end of May. It may be that they extend it. I think they probably will, and I think everything will be aligned, won't it, with the lockdown. So once we get further information on how long that's going to carry on for, then I think that the furlough scheme will be aligned for that. I also think that the commitment that they've given to making sure that, you know, the funding is available and it's open-ended, and as much money as is needed will be made available, it would feel really against the grain for them then to do like a guillotine when it's clear that there are loads of employers across the country that still need this because their operations are so severely impacted. And just before I pass on, Morag, someone asked, when is the online portal likely to be live? They've said by the end of April. There's some people being quite sceptical about that and saying that's really unlikely to happen. I think it has to happen, if I'm being honest. I mean, I think they'll be working tirelessly on it, but I don't think they can expect employers to keep paying out on the promise of reimbursement unless they get the portal live for claims to go in at the end of April. So that's what they've said at this stage.
Great, thanks, Jen. I agree on the portal. I think in terms of cash flow, it's going to become more and more of an issue for employers if the portal isn't up and running and the grants don't start coming through. So I think it will be an absolute priority. My word, right, the super questions. I love that somebody submitted a question in advance that said, when is the government likely to clarify the position on holidays? And that's the $1 million question, I think. There's a number of questions around about holiday and holiday accrual. So first question, do you accrue holidays while you're on furlough? I think we're quite clear on that the answer to that is yes. I think the key question, and the one that we don't have an answer to, but it looks like we might be moving towards an answer to it, is can you take holidays while you are furloughed? And obviously that's becoming more and more of an issue. And we've got public holidays coming up this week, Friday and Monday. What do you do with those? I was on a webinar earlier today, 301 lawyers on the webinar, and we were asked a poll, which was, do you think you can take holidays while you're on furlough? And you got 3 choices. One choice was obviously yes, one was no, and the other was, I don't know, this has blown my mind. So 64% of lawyers on the call said yes, they think you can take holidays while you're on furlough, 18% said no, and 18%, which I have to say included me, said, I don't know anymore, it's blowing my mind. So you can see there's a clear majority that take the view that you can take holidays while you're on furlough. For those of you that are following it very closely, you'll have seen last week ACAS put up guidance that said that taking holidays was incompatible with furlough. And so once you were furloughed, it seemed that you were furloughed and you couldn't take holidays, which presented a very practical problem for employers where they would put staff on holiday and then, on furlough, and then at the end of the furlough period, they would still have all their accrued holiday entitlement. ACAS very quietly updated their guidance towards the end of last week. Their guidance now says If an employee is furloughed, they can still request to take holiday in the usual way. And it goes on to talk about employers may be requested, or employees may be requested to use holidays even when they're furloughed. But then it also goes to talk about how one of the reasons you'll see that the rules change to say you can carry forward holiday entitlement for 2 years. And the guidance is a bit contradictory, because then it then talks about one of the reasons why you might have to carry forward holiday into the following 2 years is because you've not been able to take it due to COVID-19 and furlough. So it's not entirely clear. I'd say on a daily basis, Jen, you'll probably agree with this, we get articles through from different QCs, tribunal judges who take a different view on this. So we got an article through this morning from an employment tribunal judge and a QC who said that he thought you couldn't take holidays while you were on furlough. We had an article through from another QC this morning that said he thought that you probably could. So you can see it really is a question that's up in the air. There is a view, however, well, before I go on to that, I just on Sunday night it was quite amusing. There was an employment lawyer who was tweeting HMRC, a poor chap at HMRC called Daniel, and she sent a question to say, can employees take holiday while on furlough? And my word, he tried to answer the question in so many different ways so as not to give a clear answer. And if you follow the tweet, it's quite funny because you can see the employment lawyer then gets quite crabbed towards the end and says, can you just tell me, basically, Daniel, can employees take holiday when they're on furlough or not? And so he replies yes, and then no doubt disappears off the Twitter feed as quickly as he possibly can. So Daniel from HMRC says that you can take holidays while you're on furlough. But the point Jen and I keep coming back to is it's not in the guidance, and I think probably deliberately so, while the government decide what view they're going to take on it. I expect we will get updated guidance at some point. And actually, I think it's maybe quite imminent, because some views that are being shared is the reason ACAS have now updated their guidance is because they've had a bit of a tip-off that when the new guidance is introduced, it will say that you can take holidays whilst you're on furlough. So there is a sense that that might be what comes out fairly soon. But the advice that we're giving clients at the moment is it depends what your attitude to risk is. We are concerned that there's a risk that if you assign part of the furlough period as holiday, that could break your 3 weeks continuity and it could put your furlough grant at risk. So if you want to take a completely risk-free approach, you wouldn't be seeking to designate some of the furlough period as holiday. There are other options, of course, we spoke before about, and now it's a lot clearer, thankfully, because of the new guidance. You can rotate staff on and off furlough. So what you could do is you could put staff on furlough, and at the start of the furlough period, you could give them 2 weeks notice or 3 weeks notice that when they come off furlough, they have to take some of their holiday entitlement. And you can, of course, as an employer, we spoke about this before, under the working time regulations, you can require employees to take holiday provided you give them double the period of notice as the holiday period itself. So if you want them to take a week, you have to give them 2 weeks notice. So that's one way around it. The other way, of course, is that you just allow employees to continue to accrue holiday during the furlough period, and then you ask them to take their holiday at the end or over the 2-year period following the end of the furlough period. The other question then that comes up as well is if employees are allowed to take holiday while they're on furlough, what are they entitled to pay? 80% or 100%? Our view is for working time holiday, certainly, you would be entitled to the 100% pay. Any holiday that you give as an employer over and above an employee's working time entitlement is absolutely up to you what rules you put in place in relation to that holiday. So one option could be if you're changing an employee's contract by asking them to sign up to furlough, at the same time you could ask them to forgo any holidays over and above their working time entitlement. Or you could ask them to agree that they get reduced pay, for example, over and up for any holidays that they take over and above their working time entitlement. And the answer to the question is it the 4 weeks working time or the 5.6 weeks? In my view, it's the 5.6 weeks that you would have to pay the 100% for, and then anything over that you could seek to change. So in summary, the answer on holidays still not clear, but I think we will get an answer soon. Jen, I don't know if you've got anything to add to that. Are you still watching that wasp?
I was just going to say, if we did a straw poll of everyone on the webinar of like basically, is your head going to explode with holiday pay and furlough? I'm going to just put it out there and say it'd be 100%.
That's totally right.
It is really, it's messy, as Morag says, I think. For me, the only piece of the puzzle really that we need is the government reassurance to employers that do whatever the heck you want with holidays, frankly. It's up to you. We're not changing that, but it won't impact, if you do, it won't impact on your clock for the purposes of the 3-week minimum. I think that's what we need from them. And I would hope that we would get that and they would just say that holidays is really a matter for you. But as you know, as lawyers, we're not prepared to give you the green light until we've got something that we can print off and put before the tribunal ultimately, or before HMRC. Yes. So yeah, that's where we are.
I'm going to push on. I'm just conscious of time. We've got a few other questions I want to cover, and then we'll come back and look at the chat and see what we can pick up. What about if you've placed someone on furlough and they then go off sick whilst they're on a furlough period? Do they come off furlough and be treated as sickness absence, or do they stay on furlough for the whole period? We had quite a debate about this last week. It's one of those ones again where I think the answer is not entirely clear. I think where we got to, well, I suppose the first question is, why is it even an issue? You know, if your staff are on furlough, are you concerned whether they're sickness absence or not sickness absence? I think there's 2 key points to that, or 2 key responses to that. One is, do you want to know about your staff's sickness absence? There's some absences you absolutely will want to know about, and we mentioned before, you know, from an ER perspective, if you've got staff that are suffering from mental ill health, for example, would you want them to be speaking to you about that so you could make sure you're providing support to them? The other issue, though, is what pay would they be entitled to? So if it is the case that if you're on furlough, you get 80%, you then go off sick. If you operate an enhanced sick pay scheme that says you get 100% of pay while you're off sick, is it in the employee's interests to move from furlough to sick? Or is it the opposite way around, where you have a sick pay scheme that says it's SSP only, in which case is it in the employee's interest there? I think it would be to remain on furlough and not go on sick leave. The other question is, if you take someone off furlough and put them on sick leave, that's likely to break your 3 weeks continuity for the purposes of the furlough grant. And really protection of that furlough grant, I think, will be the priority for most employers. So, unfortunately, it's one of those ones where our answer, again, is we don't know, it's not clear, but increasingly the advice that we're given to employers is perhaps what you do is you stop your sickness reporting process for the duration of furlough. You place people on furlough. It's a bit like maternity leave. Once you're on maternity leave, you don't have to report in your sickness. Similarly for furlough, do you just take the view then that once you're on furlough, you don't need to report in relation to sickness absence, and you're on, your status is furlough and that doesn't change. It's one that we were asked about a fair bit last week, but it doesn't seem to be covered quite so much in the commentary this week. So it may be that a lot of employers have just taken the view, you know what, if you're on furlough, we don't want to know, or we don't need to know if you're sick during that period. The third super question I wanted to cover was who can go on furlough, and there's still 2 categories of individuals, I think, where it's not entirely clear. So it's great now under the guidance that we have the indication that those that are shielding can be on furlough even if they're not at risk of redundancy. So that kind of second category that Jen spoke about. What about those that aren't in the shielding category? So they're not extremely vulnerable, but they have been classed as vulnerable. You'll be very familiar with this category now, over 70s, some underlying health conditions, and employees that are pregnant. So they're not sick on the face of it, so they're not entitled to SSP. Can you then furlough them even if they're not in roles that are at risk of redundancy? So they may be in a pool of staff, the rest of the staff are all in, but they're not coming into work because they feel that they fall into that vulnerable category and they can't work from home. Can you furlough them? Again, I have to say the answer to that is not clear. Increasingly, my view on that category is that you probably can furlough them, because it feels to me a wee bit like they are similar to your self-isolating group, your shielding group, where, again, they're not sick, but they're not able to do their job, but it's not clear yet. And I just wanted to pick up on one of the points Jen was making about the guidance now says that employees who are shielding or people who need to stay at home with someone that's shielding can now be placed on furlough. And we had a bit of discussion, Jen and I, about, well, what does that actually mean? Does it mean you need to stay at home to provide care for the person who is shielding? Or does it mean that you feel you need to stay at home? And I have a lot of sympathy for that category of individuals. If you have someone in your household who's classed as extremely vulnerable, you may be very concerned about going out to work and potentially catching the infection and bringing it back into the workplace. Is that enough to show that you need to stay at home with someone that is shielding? My view on that would be, I would hope so, and I would hope you would be able to put that category of individual onto furlough. Again, Jen, I don't know if you share that view or if you've got a different view on that.
No, I think you're right, and I think it's going to be very difficult for HMRC to get down to that granular level of detail and try and challenge situations like that. I think the difficulty might be as an employer if you really need that employee, like if that was a concern for you, that person should otherwise be able to do work for you, and it was quite critical to your business. I mean, the ideal situation for all of these categories of people are, can they do their work from home? Yeah. I totally get it. There might be some situations where they just can't, but I agree with you, Morag. I think taking a compassionate approach, not only compassionate but also from a public health point of view, part of the rationale for furlough is to keep as many people out of the mix, so to speak, and staying at home as possible. So if you're sense checking your rationale against those principles, I would hope that would be acceptable.
Yeah. Just going to quickly pick up, because it's caught my eye, one of the questions before I go on to talk about TUPE. The minimum period of furlough is 3 weeks. Are further periods of furlough to be taken in blocks of 3 weeks, or is the initial period only the minimum? The only minimum. As long as the individual has taken 3 weeks continuous furlough, then the grant will cover. So the next block doesn't need to be 3 weeks if there's already 3 weeks of continuity, would be my view, just in response to that question. TUPE has come up quite a few times. It's quite obviously, if you've not got a TUPE transfer coming up, you'll not be interested in this at all, but if you have, you will. Again, very conflicting viewpoints. The question being, if you take on staff as a result of TUPE after 28th of February, are you able to furlough them? Because they weren't on your payroll on 28th of February, albeit they were on the transferor's payroll on 28th of February. Yesterday, there was a view expressed by David Johnson MP, or it was tweeted that David Johnson MP had been told by the Treasury that yes, you can furlough staff in that situation. But again, as I say, I was on a webinar this morning with a number of QCs, and their view was no, you can't. Employees who TUPE transfer over can't be placed on furlough because they weren't on your payroll as at 28th of February. So if anyone has a TUPE transfer coming up, just be conscious that that's not clear currently, and it's something to think about. And actually, whether you then delay the TUPE transfer until you get that clarity is perhaps something that you want to think about. Jen touched on this question of rehiring employees who were on your payroll on the 28th of February, have then left for whatever reason and are now asking to return. We have been asked this question quite a lot by employers. Should we take those individuals on? I can't see, other than from a moral point of view, or in order to help individuals through this situation, I can absolutely see the argument there. From a legal perspective, I think if you took a very cold heart to it, you would say no, absolutely not. And there are a number of reasons for that. The first is the point Jen's already covered about, arguably, if you take them back on, then they have continuity of employment, and so their start date with you will be the date that they originally started employment with you, not the date that you took them back into work. So that's one point. The other thing is, what if you have 10 individuals who say to you they want to be taken back on and you only take back on 3 of them? Is there a risk of a discrimination claim there? If the other individuals can say, well, that is because you didn't take me back on because of my sex, my race, my disability, etc. A third reason is, once you get to the end of the furlough period and you're back in a redundancy situation, would it be unfair to select those individuals simply because you had previously made them redundant? Of course, the position of the company may have changed. Would their selection still be fair? That creates a bit of an issue for you. And the other point is, if you take the individual back on, they will, of course, start to accrue holiday entitlement once you've rehired them. So there's lots of legal reasons why you probably wouldn't want to do it, but I appreciate that there may be other reasons why you decide that you do want to do it. Just picking up quickly on some of the other, I suppose, kind of smaller questions, if you want, before we hand over to Sarah on the pension side. Just seen some of the ones that have come through. Let me see. Is there an obligation to top up salary from the 80% to the 100%? If your contract says that if we ask you to stay away from work, we'll pay you on full pay, then yes, there would be an obligation to pay 100%. But of course, when you put someone on furlough, you're seeking to change their terms and conditions of employment. So at the same time, you could agree a change to their contract to say that you'd only have to pay 80%. Does someone have to go back to work at the end of a furlough period before you can make them redundant? The answer to that is no, you don't. You can make someone redundant at the end of a furlough period, and you can issue notice to someone throughout a furlough period as well. Is car allowance included in the salary? No, it's not. That's very clear from the new guidance now. It says any benefits are not included in the value of the 80%, so holiday pay wouldn't be included. Holiday carryover, can we insist on people taking leave? We've picked up on. What else have I got here?
Maura, can I just jump in just to clarify? You'd been talking, or someone had asked a question about does it have to be 3 weeks for furlough period? And I think you were talking about if you did an initial 3 weeks and then decided to add on like another week of furlough or another 10 days, but that was back to back, so the total amount was going to be 4.5. I think that's correct. So it just has to be a minimum of 3 weeks, but you can decide how long it is. But if it's a situation where you bring someone off furlough, so say you're rotating staff and you come off furlough for 3 weeks, I think if you then put them back onto furlough, that would need to be at least another 3 week block, because it has to be a 3 week minimum. So I think someone was just wanting to clarify that.
Yeah. And another point on that, I don't know, Jen, if you want to pick this one up, but can you ask someone to come back from furlough after 2 weeks if there's a change in circumstances? So, for example, the business suddenly needs them. Do you want to pick that one up?
Yeah, I think, and that's what we've been ensuring is kind of outlined in the furlough letters that you're issuing to people. So you reserve the right to bring the furlough to an end basically at your discretion. You give reasonable notice. But I guess just always remember you've got two tracks running here. One is your employment contract track, and so you can ask them to come back or direct them to come back. But what does that mean for your funding? So if you had said originally we envisage this to be probably 3 weeks at a minimum, then you actually write out and say, no, we want you to come back sooner. That's only 10 days into the furlough. You will do that in the knowledge that you won't be eligible for the funding anymore, but you may just take the view, well, that's still fine, because from a business perspective, we need people back. Someone had also just asked about fixed term contracts, and that's covered in the updated bulletin that we sent out. So yes, you can extend fixed term contracts that were due to come to an end and furlough those individuals. That's not a problem. You can decide to do that. Again, I would just say, make sure that you're doing that within the spirit of the scheme, and that you're testing your rationale for doing that. But it's absolutely possible, and it's covered specifically in the guidance.
Yeah, but before we hand over to Sarah on pensions, I'm conscious of time, but this is an interesting one. Can you ask, one of the questions that's been posted, can you ask employees to engage in consultation for redundancy, TUPE, whilst furloughed? Would that impact claiming under the grant? My view on this previously was I think you can still speak to employees as part of the redundancy and TUPE consultation whilst they're furloughed. But my view on that, I'm maybe a bit less strong on my view on that, again, following a session I was in this morning, where one of the questions that was asked there was, if you furloughed someone, can you ask them to prepare a handover note or to have a call with you to discuss handover once they're on furlough? And the view taken there was, well, no, anything that's in any way connected with work, you can ask an individual to do whilst they've been furloughed. So, arguably, consultation in relation to redundancy and TUPE could be connected with work, and then can you ask people to take part in that whilst they've been furloughed? Jen, I don't know if you've got a view on that. I go back and forward on it.
Yeah, I mean, I think it's one of these things that's probably not been thought through carefully. All I would say is that they have said in the guidance that people can be dismissed by reason of redundancy while they're on furlough. So it would seem totally illogical to say you've got the green light in that for, in principle, while they know that to do that fairly, you would need to consult with people. I guess just tread very carefully and make a judgment call about whether it's worth that that risk for the benefit of, the 2 weeks extra or whatever. I mean, I guess for collective consultation purposes, it may well be hugely beneficial for you to start consultation while furlough's ongoing. And as with all of these really high stake questions, you may decide as an organisation you're going to seek comfort from HMRC on those points, and not just Daniel on Twitter, but you'll all have interactions with HMRC already through your normal business dealings, and so where there's a lack of clarity on certain things that are going to be fairly high stake decisions for you, I think you can legitimately ask for some comfort on that.
Yeah, it's a good point. Right, I'm going to hand over to Sarah on pensions because, as I say, I'm conscious of time. Big time, Sarah. So if you want to take over and chat through some of the points on pensions and job retention scheme, that would be perfect.
Thanks, Morag. Hi, everyone. Delighted to be joining you on this webinar. I've got 5 points that I wanted to make about the job retention scheme and pensions, and they reflect questions that have been put to us over the last couple of weeks. I'll also pick up, there's a question come in while we've been doing the webinar, so I'll pick that one up as well. So the first point is, or the first question that we're continually asked is what pension contributions are covered by this scheme? And the guidance clearly says that employer national insurance contributions and minimum auto-enrollment employer pension contributions will be covered. There was initially some confusion about that minimum auto-enrollment contribution, as the original guidance referred to 3% of qualifying earnings. And of course, many employers, many of you included, I suspect, don't calculate minimum contributions on that basis. They use one of the alternative certification bases for calculating the minimum, which instead of 3% of qualifying earnings can be 4% of basic pay. And there are 3 sets of alternative certifications that you can opt for. The new guidance helpfully dropped the specific reference to 3% of qualifying earnings, which coming back to Jen's point at the beginning around this isn't precise language and we have to interpret it as best we can. Our interpretation of the dropping of that 3% qualifying earnings is that actually you'll be able to claim the minimum on whatever basis you calculate the minimum employer contribution, which is helpful because then it's not just all about the maths, whereby if you use an alternative basis, are you going to have to then calculate what 3% of qualifying earnings would have been and only claim that and have to top up the difference? So we're hopeful that that's what it means. The guidance still says that further guidance will come out on the method by which those claims should be calculated. So it may be that further information is provided, which would be helpful. What is clear from the guidance, though, is that if you're an employer who pays more than the minimum for auto-enrollment, that top-up effectively will not be covered by the scheme, and that will still lie with you to be paid. So that then tends to lead on to the question, can contributions be reduced during this period? And the short answer, helpfully or not, is yes, but. If you want the furlough scheme to be totally cost neutral and you don't just pay auto-enrollment minimum contributions, then as part of the agreement to change the terms and conditions for furloughed employees, you'll have to cover pensions as well as pay. And any changes to those terms might also have to be reflected in the scheme rules, and that will just depend on the way in which your scheme is structured. So it's just something to bear in mind. But there's really 2 key points that you've got to consider if you're looking to reduce contributions. One, those contributions can't drop below the auto-enrollment minimum. Now, there are 2 aspects to that. The first is the minimum employer contribution, but then of course you've got the minimum overall contribution for auto-enrollment. And so one issue that's come up is, well, if you drop the employer contribution to the minimum, does that mean that employee contributions have to go up to meet that total minimum? Yes, it does, because you can't pay below the total minimum. So that's just something to bear in mind if you're looking at this. And the second issue is there is a legislative requirement to consult on any increase in, any reduction in employer contributions, or indeed any increase in employee contributions. So that 60-day consultation is clearly impractical in the current circumstances. And although the guidance doesn't cover this, the pensions regulator has made various statements about seeking to take a pragmatic approach to enforcement in the current circumstances. So the view that we are taking in relation to employers who are asking this question is, given the policy behind the furlough scheme is to get people on furlough as swiftly as possible, and the regulator is saying they'll take a pragmatic approach, our view is that if you provide information to staff about why you're doing this as part and parcel of the discussions you're having about putting them on furlough, and they consent to that reduction, then it's got to be low risk that the regulator would take any enforcement action. Can't unfortunately say there's no risk whatsoever, but we would hope that that risk is very, very low. Another question we're frequently being asked is, can employees, whose salaries are being reduced during this period, opt out of the scheme or reduce their contributions? The answer to that one is you'll need to check the rules of your particular arrangement, but many of them will allow a short-term reduction or suspension of member contributions in certain circumstances. Two things to watch out for if this is a route that you're going down. If the scheme's an auto-enrollment scheme, then you as an employer cannot take steps to incentivize employees to opt out. So you just have to be careful what you're saying about this. It's fine to flag that the option is there and ask them to speak to either the provider or the trustees, depending on the type of scheme you have, but just don't step over the line of incentivization. And if employees do want to do this, you'll also need to make them aware of any impact on employer contributions. Most of the time, if an employee opts to stop their contributions, they also lose the employer contributions. So it's just being clear about the total circumstances that would surround that kind of arrangement. The thorny issue of salary sacrifice. This is not easy, and it's one of those areas where it can make your head explode, along with the holiday stuff. One question that's come in while we've been on the webinar is whether calculating your claim under the scheme, should you be taking 80% of gross pay or 80% of pay after deduction for salary sacrifice. The updated guidance is very clear on that. The salary that has to be used for calculating furlough pay is the salary after sacrifice. Okay, so we do have a clear answer on that point. But although you can claim minimum auto-enrollment contributions under the scheme to cover the employer's contributions, the employer will still have to make that payment on behalf of the employee to the pension arrangement. You won't be able to claim for that, even though under the salary sacrifice arrangement, you will be obliged to make that payment into the employee's pension scheme. So you'll still need to pay that sacrificed amount to the employee's pension arrangement as normal. You'll not be able to reclaim that from the government, and therefore you might want to think about whether you still want to operate salary sacrifice for pension contributions in the current circumstances. If you don't, then that would need to be agreed as part of the furlough terms, because of course salary sacrifice is a contractual arrangement. And again, helpfully, the government guidance now says that COVID-19 will be viewed as a life event, which would legitimately allow employees to opt out of salary sacrifice and come back into a non-salary sacrifice arrangement. Of course, that won't impact on your 80% claim for, your furloughed pay claim, because of course the salary that you're looking at, you're looking backwards, you're not looking forwards at the amount of salary people are receiving. So there are various things to be weighed up there, and that's why it's quite difficult. If you do want to maintain your salary sacrifice arrangement, you'll need to make clear to staff that it will operate in relation to reduced salary, and also it does we've sat and done some numbers, and I always say there's a reason we're lawyers and not actuaries, which is numbers isn't really our thing, but we've sat and worked with various numbers, and employees who are in a salary sacrifice arrangement will be disadvantaged compared to those who are not. So again, that's just something to bear in mind. And then the last point I wanted to flag just on here is death and service benefits. If you are using furloughed salary, that ought to flow through to any contractual commitment to pay a multiple of salary on death and service. But the definitions will need to be checked, and you'll also need to check with your insurer, because the policy that sits behind that contractual promise might have a different definition of salary and might actually allow for non-furloughed salary to continue to apply. But again, it will be a question of checking the terms in your insurance policy and checking in with your insurer.
Brilliant.
And that's all I had.
Thank you, Sarah. Thank you very much for joining us today. Right, we're at past. There's questions we've answered, questions we haven't. We will try and pick the ones up that we haven't next week. We've got another webinar scheduled to take place next week. Who knows, we might have new updated guidance before next week, or we may not. I suppose to sum it up, there's lots of known knowns now. There's still quite a few unknown or known unknowns. I suspect there's probably quite a lot of unknown unknowns as well that we still haven't thought about yet, but that might come up over the course of the next few weeks. So we'll keep you as updated as we can. I hope that's helpful. You can sign up to our database to receive updates if you've not already done that. If you go onto the website and go onto the Contact Us section, there's a link there for subscribing to database updates. So please do sign up to that if you want to make sure you receive any updated notes. Thank you again for your time. And for those of you that are joining us next week, we'll see you then. All right. Thanks. Bye now.
Bye.